When love meets litigation, logic takes the day off. Welcome to the courtroom of chaos, where he said, she said somehow becomes a legal strategy. 1. The case of the missing mustard. It started as a simple sandwich argument and ended in small claims court. A couple in Ohio sued each other over who ate the last of the Dijon. The husband claimed it was theft of property. The wife countersued for emotional distress, insisting she'd been gaslit over condiments for years. The judge, likely reconsidering all life choices, asked if either party had considered buying another jar. When both refused on principle, he ruled that whoever brought the mustard to court could keep it. The wife won, the husband appealed, and America got one more data point proving that in relationships, it's never really about the mustard. 2. The cat custody crisis. When a California couple broke up, they didn't fight over the house or the car. They fought over Mr. Whiskers, a cat with a Napoleon complex and a $400 designer litter box. The man argued he'd bonded with the cat through late-night gaming sessions. The woman countered that the cat emotionally identified as hers because she managed its Instagram. The judge, forced to read 17 pages of feline-related evidence, ultimately granted shared custody with alternating weekends and vet bills split evenly. Mr. Whiskers reportedly spent the next year peeing on both their pillows, a furry symbol of judicial equality. 3. The wedding that went to trial. In Texas, one wedding didn't end with "I do," it ended with "I sue." The bride sued her ex-fiancé for emotional damages after he proposed, planned a $30,000 wedding, and then called it off because Mercury was in retrograde. He defended himself by claiming spiritual interference. The court wasn't amused. The bride presented invoices for floral arrangements, catering, and what she called psychic trauma. The groom tried to counter by subpoenaing her astrology app to prove energetic incompatibility. The judge, clearly done with humanity, ruled that astrology isn't admissible evidence and that the defendant owed $15,000 and a written apology in plain English, not moon phases. 4. The psychic neighbor lawsuit. A Florida man sued his next-door neighbor for spiritual harassment, claiming she was using psychic waves to make his dog bark and his lawn die. He brought evidence: a tinfoil hat, several wilted plants, and a notebook filled with what he described as telepathic transcripts. The neighbor, a retired librarian who occasionally read tarot for fun, countered that her only psychic power was predicting this lawsuit would be stupid. The judge, showing saint-like restraint, allowed him to call one witness, his dog, who barked at the bailiff and then fell asleep. When asked for proof of psychic interference, the plaintiff dramatically shouted, "She's doing it right now!" The lights flickered because of a thunderstorm, and he screamed, "See?" The case was dismissed within minutes. The judge later admitted it was the first time he'd written, "Defendant not guilty due to lack of psychic evidence." Florida, where even your lawsuits need exorcisms. 5. The taco text trial. In Arizona, a woman sued her ex-boyfriend for intentional emotional deception after he texted her that he'd bring tacos and didn't. Her lawyer argued it constituted a verbal contract for food delivery and affection. The defendant's response? "I changed my mind." The courtroom devolved into a debate about what qualifies as a legally binding taco promise. The plaintiff presented screenshots, timestamps, and even a witness who'd been emotionally invested in the idea of tacos. The judge asked if she'd suffered damages. "Yes," she said, "hunger and heartbreak." Ultimately, the case was dismissed, but not before the judge delivered the most iconic legal statement of his career. This court cannot compel a man to deliver tacos, only justice. Local headlines dubbed it Taco versus Trust. Ironically, both parties reconciled months later at a Taco Bell drive-thru in 6. The ghosting lawsuit. A man in Illinois took ghosting to a new level. He actually sued his ex-girlfriend for vanishing mid-relationship. He claimed emotional fraud, insisting she'd pretended to be in love before disappearing like a Netflix subscription trial. His 14-page complaint included text transcripts, Venmo receipts, and a printed meme reading, "She said forever." The defense attorney, likely questioning her career path, calmly explained that ghosting isn't illegal, just awful. The plaintiff argued that digital disappearance should count as abandonment under emotional contract law. The judge disagreed, suggesting therapy instead of litigation. But the best moment came when the ex-girlfriend finally showed up. To say she hadn't ghosted him, she'd just blocked him for his own sanity. The case was dismissed, and the judge's final note read simply, "Court recommends counseling for both parties and possibly the internet." 7. The chicken nugget custody case. Divorce brings out the worst in people, and sometimes the weirdest. A couple in Kentucky made national headlines when they spent 3 full days in court arguing over who deserved custody of their freezer full of chicken nuggets. The wife claimed they were an emotional staple during tough times, while the husband countered that he'd been the one to marinate the memories. The freezer inventory, meticulously cataloged and submitted as evidence, included 47 bags of nuggets, 12 dipping sauces, and 1 suspiciously empty ranch container. The judge asked if they realized frozen food depreciates in value. The husband shouted, "Not emotionally." Ultimately, the court ruled that the nuggets be split evenly, with alternating custody of the freezer until supplies ran out. The judge, visibly exhausted, closed the case by saying, "May your future meals bring peace, not litigation." Reportedly, they later reunited over a McDonald's Happy Meal. 8. The haunted rental lawsuit. A couple in New York sued their landlord for failing to disclose that their rental home was haunted. Their evidence? Cold spots, creaky floors, and a ghost that allegedly smelled faintly of cigars and regret. They argued that being haunted made the property unlivable and demanded a refund for emotional terror. The landlord, unfazed, produced a statement from the previous tenant claiming the ghost was friendly if judgmental. Things escalated when the couple brought in a psychic witness who declared that the ghost just wants attention and a decent Wi-Fi signal. The judge admitted he couldn't legally evict a spirit, but did rule the property psychologically stigmatized, setting a precedent for spectral disclosure. The case became famous as the Ghost vs. Lease Agreement, and paranormal law professors still use it to explain how logic occasionally takes a coffee break in courtrooms. 9. The Lawnmower marriage dispute. In a Minnesota divorce case, the couple's biggest disagreement wasn't money, property, or pets. It was the lawnmower. The husband insisted it was his first love, claiming he'd personally waxed it every spring. The wife countered that she'd mowed 95% of those lawns and therefore had primary custody rights. Their lawyers, visibly drained, submitted maintenance logs and even photos of each mowing session. The court spent 6 hours reviewing grass-cutting schedules before the judge asked, "Why not just buy another mower?" Both shouted in unison, "It's not the same!" The final verdict granted joint custody, alternating weekends and shared fuel expenses. When asked if they'd consider reconciliation, the wife said, "Not unless he learns to edge properly." The mower, according to neighbors, now sits peacefully between 2 yards, the most legally supervised grass in America. 10. The parking lot proposal lawsuit. Some people sue for money, others sue for closure. A woman in Nevada did both after her boyfriend proposed in a Walmart parking lot. She claimed emotional damages because the proposal failed to meet her romantic expectations. In her words, "If I'm saying yes next to a shopping cart return, that's false advertising." Her attorney argued it was a violation of implied emotional quality. The man defended himself by stating he chose Walmart because it's where love and low prices meet. The judge, barely keeping a straight face, asked if the plaintiff suffered any measurable harm. "Only lifelong embarrassment," she said. The court ruled in the boyfriend's favor, stating that bad taste is not a tort. Ironically, the woman later sold her key story to a reality show for triple what she sued for. The episode title, Rollback Romance, Love and Lawsuits. 11. The sandwich of suspicion. In Georgia, a man sued his co-worker for intentional sandwich sabotage. The claim? His lunch was mysteriously swapped with a vegan wrap. He accused the co-worker of culinary defamation and assault by flavor. Security footage showed the two arguing near the office fridge, but no clear evidence of tampering. During testimony, the plaintiff described the taste as so aggressively green it ruined my week. The defense argued the swap was accidental and introduced an airtight alibi. He can't tell the difference between kale and lettuce. The judge, weary of humanity, dismissed the case, reminding both parties that the court is not a cafeteria. Ironically, after the case went viral, a sandwich chain offered them a joint sponsorship deal, proof that in America, even your dumbest lunch fight can turn into a business opportunity. 12. The jury duty breakup. A man in Colorado sued his ex-girlfriend for breaking up with him via text while he was serving on jury duty, claiming cruel and unusual emotional timing. He argued her message, "It's not you, it's your indecisiveness," distracted him so much he couldn't deliberate properly. The foreman testified that the man spent hours staring at his phone, muttering, "Objection, relevance," to no one. The defense attorney simply read the breakup text aloud, prompting the courtroom to collectively sigh. The judge, suppressing laughter, ruled that heartbreak, while inconvenient, is not a judicial emergency. The plaintiff lost, but later became a motivational speaker on resilience through rejection. His talk title? Love on Trial: How Jury Duty Broke My Heart and My Case. It's still unclear whether the ex ever watched the speech. Sources say she was deliberately unavailable. 13. The Great Soup Explosion Case in Nugget, Michigan. A man sued his microwave manufacturer after heating a can of soup without opening it first. When the can exploded, coating his kitchen and himself in what the lawsuit described as molten chowder, he claimed the product failed to warn about pressurized consequences. The defense simply presented the can's label, "Do not microwave unopened." He countered, "I don't read warnings unless they're on fire." The judge called it a self-inflicted lunch disaster and dismissed the case. But the story didn't end there. The man went viral online, branding himself the soup guy, and later appeared in an ad campaign about kitchen safety. Ironically, his tagline was, "Always read the label." He made more money from that commercial than he ever could have won in court, proving that in America, stupidity might just be the most lucrative business model of all. 14. The Wi-Fi wedding disaster. In California, a couple sued their wedding planner for emotional negligence after the venue's Wi-Fi went down during their ceremony. Their reason? Guests couldn't live stream the event on Instagram. The bride testified that her digital audience was more important than the physical one, claiming she'd lost engagement both emotionally and algorithmically. The planner argued that weddings existed long before Wi-Fi, which only enraged the couple further. They presented screenshots showing a tragic dip in likes during the outage. The judge, visibly done with humanity, asked, "Did you actually enjoy the wedding?" The bride replied, "Not without Wi-Fi." The case was dismissed, but the story went viral anyway, ironically giving them the social media fame they'd wanted all along. The headline the next day summed it up perfectly. Couple loses case, gains clout. 15. The lottery love lawsuit. A man in North Carolina sued his ex-girlfriend after she broke up with him the day after winning the lottery. He claimed relationship fraud, insisting she'd only stayed with him until her ticket hit. Her defense was simple: "I bought the ticket with my own bad decisions." The plaintiff demanded half her winnings as emotional investment returns. During cross-examination, he admitted his biggest contribution to the relationship was moral support and good vibes. The judge ruled that vibes do not constitute legal tender, dismissing the case. However, the woman later sent her ex a $5 scratch-off in the mail with a note, "This is all you're entitled to." Ironically, it was a loser, just like his lawsuit. 16. The Great Banana Slip Blame Game. A grocery store customer in Oregon sued the store after slipping on a banana peel, except security footage showed him dropping it 10 seconds earlier. In court, he argued that time distortion made it seem like it was his fault. His lawyer tried to claim banana peel blindness, saying bright yellow colors can cause visual confusion under fluorescent lights. The judge, barely hiding a smirk, called it the most appealing argument I've ever heard. The plaintiff doubled down, saying the peel was emotionally manipulative. After the case was thrown out, the man vowed to appeal. The store manager, interviewed later, said the peel was still the most honest customer they'd ever dealt with. It didn't lie, it just slipped quietly out of the case. The man later sued his lawyer too, for insufficient enthusiasm. 17. The Emotional Support Peacock Incident. An airline in New Jersey faced a lawsuit from a woman who tried to board with her emotional support peacock. When staff refused, citing safety and sanity, she sued for discrimination under avian emotional rights. Her argument? "He's not a bird, he's my soulmate with feathers." The airline presented evidence showing the peacock had attacked 2 gate agents and defecated on a luggage carousel. The judge asked whether the animal was trained. She replied, "He's self-taught." The court dismissed the case after the peacock loudly interrupted proceedings, screaming what one reporter described as a sound resembling legal protest. The woman later started a blog called Flightless Together about the pain of emotional support rejection. It gained 5,000 followers, and, tragically, not a single airline sponsor. 18. The psychic traffic accident. A self-proclaimed psychic in Texas sued another driver after a fender bender, arguing it never should have happened because she had predicted it. Her claim? He disrupted the timeline I foresaw. The defendant countered that if she truly saw the future, she could have hit the brakes. The courtroom erupted when she dramatically held up tarot cards mid-testimony and shouted, "The tower reversed!" The judge calmly replied, "Ma'am, we're not reversing anything today." Her lawyer tried to argue for metaphysical damages, but the case was thrown out when she refused to answer yes or no questions, insisting she could feel the answers cosmically. The official court record summarized it perfectly. Case dismissed due to divine confusion. 19. The Instagram defamation case. A fitness influencer from Los Angeles sued her ex-friend for defamation after being tagged in a post that read, "Some people fake squats and friendships." She claimed it cost her thousands in brand deals and irreparably damaged her glute credibility. The defense argued that the post didn't name her, but the plaintiff presented 42 screenshots of comments where people guessed correctly. The judge, presumably regretting law school, ruled that being indirectly roasted on Instagram is not a legal injury. However, he did advise both parties to touch grass, not lawyers. Ironically, the viral court case boosted both their follower counts by 200%. They later collaborated on a fitness video titled Leg Day, the lawsuit edition. Humanity, it seems, has no cool-down period for dumb. 20. The drive-thru coffee catastrophe. In Seattle, a man sued a drive-thru barista for emotional distress after she allegedly winked at him while handing over his latte. He claimed the wink created false hope of romantic intent. His evidence included a diary entry, the coffee cup in question, and a poem titled Love in Line 3. The barista testified that she was simply trying to blink away whipped cream foam. The judge ruled the lawsuit frivolous, but did commend the man's commitment to delusion. Outside the courthouse, he told reporters, "I still think she meant it." The story went viral, and the coffee shop released a limited edition drink called the Flirtuccino. It sold out in hours. The barista made Employee of the Month. The man, he later filed for copyright on the poem. 21. The case of the kidnapped garden gnome. In Vermont, a man sued his neighbor for emotional torment after his prized garden gnome went missing, then began reappearing in photos emailed from around the world. The gnome, named Gerald, was pictured in Paris, Tokyo, and even outside the White House, holding a sign that read, "Wish you were here." The plaintiff insisted it was a psychological hostage situation. The neighbor, who turned out to be the prankster behind the photos, said it was performance art celebrating global unity. The judge, trying not to laugh, declared that kidnapping a gnome is not a crime, but it is deeply weird. The case was dismissed, but the gnome's travels continued, gaining over 50,000 Instagram followers. Eventually, Gerald was returned home with a tiny passport and sunglasses. The judge's closing statement summed it up best. Case closed, vacation complete. 22. The salad dressing dispute. At a small-town diner in Ohio, a couple took their breakup to court over, of all things, salad dressing. The girlfriend claimed her ex stole her secret, ranch recipe, while the defendant said he merely improved it with love and paprika. They both brought jars of dressing as evidence, forcing the judge to perform an impromptu taste test. After sampling both, the judge sighed. "They're identical, and I now regret lunch." The court ruled that salad dressing didn't qualify as intellectual property. The plaintiff stormed out shouting, "You can't trademark love." Local news dubbed it ranch versus romance. Ironically, the couple later reunited to sell their dressing online under the name Emotional Damage Ranch, proving that heartbreak and hidden ingredients are both commercially viable. 23. The Great Zoom Court Cat Fiasco. During a virtual court hearing in Texas, a lawyer accidentally appeared with a cat filter on his webcam and couldn't turn it off. "I'm not a cat, Your Honor," he pleaded, as the animated feline face blinked nervously. The clip went viral, but the opposing party took it further, suing for mockery-induced emotional distress, claiming the viral fame made their case look like a cartoon. The judge, now internet famous himself, ruled that Zoom filters are not a basis for damages. He added, "If we start suing over cat filters, civilization is doomed." The plaintiff lost but gained sympathy and several 100,000 views. The lawyer, meanwhile, embraced his new nickname, Persecutor at Law. Humans will sue over anything, cats, condiments, or ghosts. Which courtroom circus deserves a trophy for stupidity? Your verdict, please.